We're also here, my lord.
Thank you, Mr. Trengrove. And Mr. Roux? Mr. Roux, are you there?
Thank you, my lord, to be here.
Thank you. And then Mr. Zuma?
Yes, I'm around.
Thank you. Thank you very much. It seems we all seem to be back. Mr. Masuku, your reply?
Thank you, my lord. May I start by looking at the scope of today's proceedings?
Yes.
Which Mr. Mpofu has clearly explained. And they also come from your lordship's directive,
yes,
which appears in MPT 4 in the founding affidavit. In that directive, your lordship says, having considered the responses received from the parties and having regard to the contents of Mr. Downer's letter addressed to me, dated 14 July 2021, recording what he was advised by the head of the Escort Correctional Facility, I hereby direct that the proceedings in the above trial, scheduled to commence on 19 July 2021, shall proceed virtually.
Yes.
And here is why we're here today. If a postponement is required, then a substantive application will be required to be brought.
Yes.
This is a postponement in accordance with the directive of the court. In other words, the scope of submissions that that can responsibly be met are submissions that are directed at whether or not it is consistent with the accused's constitutional rights in Section 35(3) of the Constitution to have the matter proceed virtually. And there's another related submission to that, is that a virtual hearing is an exception. It is a virtual hearing in criminal matters is an exception. In other words, it constitutes a limitation of the scope of rights that an accused person is entitled under Section 35. And therefore, it must be justified in terms of Section 36 of the Constitution. And that is very important, my lord, because you have to ask yourself with respect whether or not a directive that an critical aspect of a plea that may well result in the acquittal of the accused is in fact heard in his physical absence. The arguments around whether or not he's physically present, I'm not going to deal with that. He's not here. He's not in court. We see him virtually, but he is not in court. So what your lordship has to then consider in evaluating the cogency of the postponement application is whether or not the applicant for the postponement has made out a case in relation to the rights that are a subject of the trial. In other words, has the applicant made out a case that, given the circumstances that have resulted in adopting this exceptional manner of hearing this case, which is by virtual, the very circumstances that have resulted in us, in your lordship, directing that a virtual hearing be the manner in which we proceed, which is the disruption in the court, the absence of the accused because he's incarcerated, and the fact that he has now filed a Section 108 plea in terms of which Section 108 notice in terms of which he would like oral evidence to be led in his plea. Now, those are not matters that ought to be decided that ought to be decided in this particular hearing. What has to be decided here is whether or not, in terms of Section 36, the less restrictive means to achieve the purpose of the trial, the purpose of the hearing of the plea, is more appropriate, and the less restrictive means is a postponement. And my lord, you have to ask yourself in the arguments that were advanced by my learned friend for the NPA, Mr. Trenkov, not once did he refer to the prejudice that the state would suffer if there's a 1 or 2 or 3 weeks postponement. Not one allegation I can recall him making in terms of which he said the administration of justice would be undermined if a postponement of 1 or 2 weeks is granted in order to ensure that the ideal constitutional conditions for conducting this particular trial are achieved.
Yes.
Not once. So would ask that in determining this application, confine yourself with respect to whether or not a case for postponement has been made out. By reference to the rights that the applicant for postponement is asserting. My learned friend for Mr. Trenkov started off by reminding us although irrelevant, is tried to remind us, or rather reminded us, what the state's obligations are in relation to the prosecution of crime, not just corruption, but crime. That takes the matter nowhere. Because in so saying, he was not suggesting that a postponement of a week or 2 or 3, in fact, it would be inconsistent with that purpose of prosecuting crime by the state. He couldn't suggest that, because clearly that suggestion would be wrong. But in explaining what the duties of the state to prosecute corruption are, he did not refer, Your Lordship, to any provisions in the Constitution that govern how that prosecution must take place. The specific constitutional circumstances that are prescribed for the conduct for performing this particular function of prosecuting crime. And Your Lordship, I would suggest that Your Lordship refers to Section 7 of the Constitution, which binds not just the NPA, but binds the court as well. Section 7 of the Constitution, Section 7.2 of the Constitution, which says that the state must give effect, the state must respect, protect, promote, and fulfill the rights in the Bill of Rights. One must ask whether the NPA's conduct in opposing this postponement, which is not an opposition that appears to be reasonable, because this is not a postponement intended to frustrate the hearing of the conduct of the trial. We're already in the trial. The state is already prosecuting Mr. Zuma. He has already pleaded to the charges. What we need to do is to infuse in our procedural options the requirement of respect, of protecting and promoting and fulfilling the right in Section 35, of the Constitution. My Lord, I would urge that you also look at Section 8, which binds Your Lordship, which says that the Bill of Rights applies to all law and binds the legislature, the executive, and the judiciary. That means that Your Lordship, in making a deviation from the normal procedure in prosecutions, that they are bound to look at whether that deviation in terms of the procedure has the most important attribute, which is the protection of the rights of the accused, or the protection of the integrity of the prosecution itself, the constitutional integrity of the prosecution itself. And with respect, we would say that in the circumstances where Your Lordship has invited parties who wish to ask for a postponement to do so, and to set out the basis on which that postponement should be granted, if Your Lordship does go that far. It is expected that Your Lordship would then weigh the procedural option of postponing the application with due regard to the rights of the accused. Does a postponement give effect to the rights of the accused person, in the sense that the accused person would be tried in the constitutionally ideal or prescribed conditions, where he's present in court, where he's able to consult with his lawyers or his lawyers, and where he is able to follow both the legal and the factual arguments, the basis on which an acquittal is being sought in his particular case. So it doesn't help to suggest, to scramble to find a constitutional basis on which a virtual hearing should be justified under these circumstances. An accused person says, I am not prejudiced if you postpone for 2 or 3 weeks. I'm not prejudiced. The state doesn't say he's prejudiced. The state does not say it is prejudiced. The state does not say the court is prejudiced. In fact, the court itself says invites parties who wish to have this matter postponed to actually bring an application for postponement. In those circumstances, the only question that the court must consider is to weigh a virtual hearing, its advantages and its disadvantages vis-a-vis a postponement. What are the advantages of a virtual hearing? As far as the advantages from listening to my learned friend, the advantages are that the matter is going to be expedited. In fact, if your lordship were to dismiss this application on the basis of what the NPA says, you'd be dismissed it on the basis really that this application for postponement is another attempt, which is also false, another attempt by the accused to delay the prosecution. This case has been on the national scene for over 15 years. And the greatest part of the delays have been the state's handling of the case. State is solely responsible for the 15+ years of delay in bringing a lawful prosecution. We're here because the state has been told by the SCA that go and do the job, go and do your job properly, prosecute the man properly, and to try and then come up with the shortcuts of hearings in his absence, we're introducing further difficulties in terms of the conditions under which the accused person should be tried. The accused person is here, but he's not here in a courtroom where he's able to consult with his lawyers, where he's able to. I mean, this suggestion, maybe I should dismiss it very quickly. This suggestion that we can consult by telephone of some official of the correctional service is also very awkward for coming from a body like the NPA, because I mean they are not ideal circumstances for looking at your client as a lawyer and determining whether they're comfortable with the advice you're giving them, or just being in the presence of your client when you advise them on what it is that they need to understand about the trial that they are facing or the proceedings of the trial.
But the scope for taking instructions is obviously considerably less when one is dealing only with issues on paper, by way of exchange of affidavits.
Yes, I accept that, but here is the difference. Your lordship must not accept the state's approach of wishing to have this matter dealt with on paper, because we know that on paper their arguments are these issues have already been decided. So what they really want is the opportunity to come armed with civil judgments in civil courts, which have dealt with one or other aspect.
Yes, I understand that's going to be part of your argument, and I don't want to interrupt your argument. In the fullness of time, you'll contend that they're different, they're civil proceedings, etc. But I was raising it at the level of that inability to consult with your client is different where the matter is being argued on papers as opposed to a trial.
No, this is the answer I was trying to give, my lord. Perhaps I was I was inelegant in giving the answer. Let me try again. And maybe I needed a bit of water to do that. But here is the answer that I'm trying to give to your lordship. Firstly, it is wrong that there are no disputes of fact. This case is heavily disputed. Mr. Downer's entire premise is that there is no prosecutorial misconduct, the nature of which has undermined the fair trial rights of Mr. Zuma. If we are right that there is enough evidence coming from the NPA itself that the nature of the misconduct, properly tried, properly tested, is such that the fair trial rights have been violated, we would be entitled to an acquittal. We would be entitled to have the court say, NPA, the evidence that I have here is so bad, and the evidence you have, my lord, just on the papers, is such that that should horrify any accused person completely. So,
I think the point that is,
my lord, I would really, I do want to make my submissions on the question that you asked me, which is whether or not there is a problem with the consultation. The applicant for a postponement is entitled to follow the legal arguments that are made in court, to follow the legal arguments, not just virtually, to be able at an instant to ask the lawyers a particular question relating to an argument being made. These arguments on paper are not argued. These are not legal arguments only. The arguments that that contain facts that are disputed, heavily disputed facts. To try and strip things and say, well, he's entitled only to hear virtually legal arguments in a trial, is to suggest that where legal arguments are being made with the potency of getting an acquittal on the basis of those legal arguments, he's not supposed to be there. With respect, that would not be correct. He's entitled to be present in court to follow the arguments that are being made, whether they're factual arguments or legal arguments, whether they're on paper or they're not on paper. He is entitled to sit with his lawyers to follow what is going on in a courtroom. He is also, my lord, with respect, entitled to watch the bench to see how the court is responding to the various arguments that are being made, and to make his own assessment of where the case may be going. Like, for example, when a court says to counsel, with respect, that argument is absurd, right? And I'm not saying that's what your lord should be saying, but I'm just saying in the engagement between counsel and the bench, the court is entitled to test the propositions of counsel by putting strong views about a particular position. An accused person is entitled to watch, not through TVs and computer screens, to look the bench in the eye, as they would put it, to look and see where that bench is leaning towards. Based on it, to say to his counsel, listen, I don't think he's going that direction. Can you make that submission that I told you about earlier on when we consulted? There and there. Right now, if you wanted to give me an instruction to say abandon this application, we would have to stop this entire proceeding in order to do that. That's not the ideal constitutional framework in terms of which accused persons in South Africa are tried or elsewhere in the world. So I would say that there's also another reason, my lord, why you need to reevaluate your directive and order a postponement. It is because we are aware, and this was a submission made or a view expressed by the NPA regarding the conduct, bringing witnesses virtually to testify against the applicant. The applicant in this postponement knows that. He knows that there is an attempt by the NPA to bring witnesses virtually. And that application will come at some point during the hearing, when the overseas witnesses need to come here and there's corona and there are problems. They are going to be coming back to your lordship to say, we need this witness to hear this, to give this evidence orally. That is a problem. And if your lordship allows the virtual hearing now, why should we not allow a virtual hearing to be conducted in terms of the whole trial? The whole trial can be done virtually.
No, every witness in every instance will have to be dealt with separately on its merits.
Yes, but we know.
There's not going to be. You can accept, Mr. Masuku, that if a virtual hearing is allowed at one point, then it doesn't necessarily mean it's going to be followed throughout.
Yes, no, I accept that, but I'm just saying that your lordship would have created a precedence through a directive that suggests that it is it is okay to conduct a trial without the rigorous requirements that are set out in the Constitution. And Lordship actually raises that in the first letter where Lordship invites us to make submissions. It's acutely aware of the baseline requirements for conducting a trial. And your Lordship says, no, we are faced with circumstances that may require us to be creative. But when we are being creative, we have to be creative and lean towards protecting the rights of the accused person. The state will not suffer any prejudice. Mr. Downer's scheme of wanting to prosecute this case will not wane because there's a 3 month postponement, or sorry, a 3-week postponement of this case. The NPA is and when I say his team, I don't mean to be vicious, but I do mean that his determination, and you can see that he's the one filing affidavits, even in this particular postponement application. He really wants to prosecute this case. And I don't understand why that cannot be done after 3 weeks when the matter is postponed. Why that arguments cannot be made after 3 weeks. So we're saying, Your Lordship, consider the scope of your ruling in terms of the directive you gave. Evaluate the state's submission relating to the actual plea itself, in terms of which you are now being asked to dismiss the plea, to dismiss the application to have oral evidence led, and basically to decide against to decide the issues of the plea, because that is not the scope of the directive that Your Lordship gave. Your directive was merely on the postponement itself.
Sorry, on the postponement itself.
Yes, the directive was that we should, if anybody wants a postponement, that should be filed. That should be provided on a substantive application. That's what we're about here.
But that was now for a postponement of the hearing that would take place virtually.
Yes. So Your Lordship interposed that procedural, that determination of a hearing on the merits by suggesting that anybody who wanted a postponement could do so. And by just reading through that meant that you would not determine whether or not the plea is good or bad.
Yes,
and that's why
if the postponement is granted.
If the postponement is granted, well, if the postponement is granted, but it obviously meant that Your Lordship would accept that a substantive application of a postponement, particularly in the terms that we have set out, would be a postponement in terms of which serious submissions would be made relating to the constitutional implications of the directive to hear this matter virtually. And we have raised that aspect of whether or not the directive does meet the Section 36 requirement. Yes. And we say it doesn't, because it is a deviation from the normal. It does not meet the requirements of Section 36, because Your Lordship will know from the arguments made on behalf of Mr. Zuma that in terms of Section 36, the limitation must be reasonable and justified in an open and democratic society based on human dignity. There is no dignity in asking Mr. Zuma to confer with his lawyers via cell phones of other people. Where is the privacy of the consultations there? There's no dignity at all. There is no equality that is advanced here, because this procedural today it's doubtful that in the Pietermaritzburg court any criminal trials are running, because we are aware of a directive by the judge president in terms of which motion and some criminal trials in P1, 2, and 3 are not running today. So we're saying that the equality the equality aspect is implicated. We're not necessarily saying that you have treated me unequally. We're simply saying that you have to say to yourself, does my directive place Mr. Zuma in a different legal or procedural platform? And it does. It suggests that it is okay when it's simple legal arguments or arguments on paper for him to be absent. And that can't be right, because his rights are as good as when he is as good when arguments are being made on paper as they are when there is oral evidence. That distinction doesn't really justify the deviation from the norm. And besides, Your Lordship is consistent with how other courts, including the Chief Justice, has basically reacted to the disturbances that have occurred. They've said, well, if you are going to adopt any procedural mechanisms for the hearing of any parties, those must never deviate from the core rights of the people or the integrity of those hearings must never be compromised because of the issues. So a postponement would simply mean that the hearing of the plea is postponed for a date where parties can assess whether or not the disturbances are such that another procedure can be adopted. And this is not new, my lord, because you will know from the history of this case that that parties have in fact agreed to postpone matters because of coronavirus. They've agreed to have the matters postponed, particularly the holding dates being moved from date 1 to date 2, and the reason being given being that the pandemic is a problem. In fact, I can recall that the state itself at some point requested a postponement on the basis that it wasn't clear whether their witnesses who are coming from overseas would be able to come during the pandemic period. And so the matter would be moved forward so that we allow the situation to abate so as to conduct an ideal trial governed by the prescribed constitutional framework. And of course, the taking into account all relevant factors, the nature of the right that is involved. The nature of the rights involved is a right to a fair trial. The purpose of the limitation. The purpose of the limitation is to determine. I don't want to give Your Lordship the rationale behind the virtual hearing. The rationale behind the virtual hearing was that there are disturbances and that Mr. Zuma is not present, and that there is a pandemic. All three are good, except that there is except that one must look at the other factors, which is the nature and extent of the limitation. The limitation is we can't consult with Mr. Zuma. We can't. The limitation is that he will have to follow the trial or on his plea that may well acquit him virtually. And the difficulties that are the physical barriers that are placed by this virtual hearing are real. And I think the court accepts in its deliberation on whether a virtual hearing or postponement is appropriate route. The relationship between the limitation and its purpose. What here, my lord, one has to look at is you have got two options. The one option is to have the matter here virtually. The other is to hear the matter postponed. Which one will not give any problems in terms of the integrity or the potential constitutional complaints that may arise out of this particular aspect? If there was no coronavirus, if there was no disturbance to the court, if Mr. Zuma was able to physically be in court, there would be absolutely no complaint. What this directive does is that it raises in an already heightened trial a procedural ruling that does not create an ideal constitutional environment for a fair trial hearing. Mr. Zuma would be justified to say that, look at this now. I'm advised by my lawyers that I should be in court hearing my plea and listening to what they are saying about the facts that underpin that plea. But I'm being forced to hear that while I'm in prison. There's so much agency that Mr. Downer and the NPA sees. There's so much agency to have this matter heard. It's 15 years down the line. A 3 months delay takes the matter no further. And there are no risks whatsoever in having this matter postponed. There's no prejudice whatsoever in having this matter postponed. In fact, a postponement would be a justified limitation of this right to have a matter heard expeditiously. Because of reasons of his absence, the coronavirus and the disturbances, a postponement, as other cases have been postponed, other cases in the same court have been postponed, would be justified in the circumstances. And we would urge your lordship to reevaluate the directive and to order that a postponement be granted.
You're not pursuing the paragraph 1 declaration of rights then?
No, we are pursuing it vigorously because, my lord, it's now clear from the arguments advanced by the state, because the state says there is no constitutional violation when a virtual hearing is directed under these circumstances. In other words, when there is a disturbance, when there is a pandemic, and when the accused person is absent, there is no constitutional violation in having the matter heard virtually. That's what the state is saying.
I understand that, but can I decide that?
Yes, you have to decide that, my lord, because I'm not even going to. My learned leader has already said to your lordship that don't worry about the fact that you are reconsidering your own directive.
No. It's informed. I hear what you say about reconsidering a directive. It's different to issuing a declaration of rights, though.
Yes, because our opponents, the people who are supposed to conduct the trial, are putting doubts around the rights that are implicated in the directive. And we want that made very clear that today, in future, a virtual hearing will only be an exception, justified by circumstances that are pleaded at that particular point. It is not right for the state, particularly the NPA, to want to treat Mr. Zuma differently. They've been doing that for too long. They must apply the law as they are commanded to do so in terms of the act. This passionate, this zealous pursuit for Mr. Zuma at all costs by bending rules and cutting corners is not right. Let's just have a fair trial. Let's have him in court. Let's have everybody there. Let's argue the case there. Mr. Trenkov can't in good conscience say that it is the platform today to decide the plea, even for purposes of a postponement, because as I understand his argument, he's suggesting that the plea is so meritless that a postponement has no value. That's his view. He has got a mandate that he carries. We've got a mandate to carry. Your lordship must hold the fort, must hold the two reins and hold the ring so that we're able to fight properly on the plea. And for that, we will debate whether or not we're entitled to cross-examine the averments made on affidavits. We'll have a debate about that later. Today, what your lordship needs to decide is whether or not you should reissue a directive in terms of which this matter is postponed to a future date. And you would be in good company, my lord, if you did so, because you will know that next door to your courtroom are matters that have already been postponed for the same reasons that this matter is being heard virtually. Even civil matters are postponed. They are not being heard because the judge president and others have decided that it's ideal for matters to be heard when there are no disruptions, when there are no potential disruptions to the running of the courtroom. So would say a postponement would would give effect to the rights of Mr. Zuma in Section 35(3). A postponement would be consistent with the proper administration of justice. A postponement would enable this matter to be tried on the merits, and no interlocutory applications ought to be easily provoked on either side. So this idea of wanting to cut loose this privilege invited by the court to seek for a postponement, to argue that the plea should be dismissed is with respect not a responsible response to your lordship's directive. Your lordship was quite clear. We're only here for a postponement, and your lordship cannot make an order dismissing the plea or make an order that the plea will go on oral evidence. That will come in its future time. Today, all we're asking is that create the ideal conditions which your lordship is aware of from the writings you have conveyed to us, and which your lordship has routinely practiced under. Just let's be normal with Mr. Zuma for a while, and create no exceptions for him. That is consistent with what our constitution says in Section 9 of the Constitution, the equality provision. My lord, I am alone here in Cape Town. I am led by someone who is in Johannesburg. I have no idea what he wants me to say as a closing remark. I've got juniors who are both in Johannesburg and in Durban. Now, this is the difficulty. Can I take 2 minutes to find out what my team has to say I should add, including the possibility of asking Mr. Zuma whether or not there's anything I have left which might persuade your lordship that a postponement is absolutely necessary to take.
Yes, Mr. Masuku, it's now 2:05. Oh, sorry, a bit more. How much time do you need?
Can we take maybe 10 minutes?
Yes, certainly. Shall we say 20 past, 25 past?
I'll take the more, 25 past.
25 past. All right.
Yes.
We'll resume at 25 past.
Thank you, my lord. Yes, my lord.
Let me just do the rounds and just check. Mr. Trengrove, are you there?
Thank you, my lord, we are.
Thank you. And Mr. Roos?
Thank you, my lord, we are.
Thank you. And then Mr. Zuma? Mr. Zuma?
Yes, I'm around.
Thank you very much. You can hear us clearly. Yes.
Yes,
Any
okay.
further questions, Mr. Masuku, or you?
Yes. No.
Glad-
My leader says he's happy with what I've said, but there are just one or two things that I need to deal with.
Yes.
The first one relates to the.
Yeah.
Oh,
Sorry.
Sorry. The first one relates to the reference to the De Beers case.
Yes.
My lord, you will see that the De Beers case is distinguishable to what is happening here. The question is never, the question that your lordship must answer is not whether or not virtual hearings are permissible in certain circumstances or not. The question is quite different. The question is whether or not the applicant in the postponement has made out a case for the matter to be postponed. We're not here trying to impugn the legality or the constitutionality of a virtual hearing, only to the extent that the declaratory order is sought. But this is not a frontal attack on the dispensation of virtual hearings.
Okay, so if I understand correctly, you're saying that there could be a virtual hearing ordered, yeah? It wouldn't be improper, but you're saying on the facts at present, it shouldn't have been granted.
Yeah, what we're saying, in a trial environment, a virtual hearing should not be granted. And because there's now a dispute with the NPA on that particular dispensation of conducting trials via virtual hearings, it does implicate constitutional rights for which a declaratory order is important, because they have put it in dispute. They've put it in dispute whether or not their circumstances. In fact, according to them, this could just be the trial. So we're saying that the De Beers case is not a case that we need to it's distinguishable from the facts of this case. This was an appeal in a Supreme Court of Appeal. It takes the matter no further than just articulating the obvious, that in certain circumstances a virtual hearing may be ordered and has been ordered in the past. And then similarly with Regulation 14 that my learned friend referred to, Regulation 14 in its other means should never be extended to mean that a trial can be conducted through a virtual hearing.
When you say trial, you mean a trial with viva voce evidence?
Yes, I mean a trial with viva voce evidence.
Yes. But an aspect of a trial that doesn't involve viva
Sorry,
voce.
my lord. Perhaps I should defer to my leader who is watching, and I see he's shaking his head. So maybe I'm doing something that he doesn't like. Can I perhaps stand down and let him?
No, he says he's shaking
No,
his
my lord, I'm happy. I just want to say what Mr. Masuku is referring to is a criminal trial, not just any trial.
Yes. All right. Okay. There we go, Mr. Masuku. Are those your submissions?
No, the last one, my lord.
I think you still have one more to deal with. Okay.
The NPA's opposition to this postponement is of grave concern for how this matter has always been dealt with. In the past, as I've said, there has been an attempt to mutually accommodate each other where postponements were necessary. Postponements has been granted by agreement between parties. And it's quite telling that when Mr. Zuma is incarcerated, that the state would insist that a plea that may result in his acquittal should in fact be debated in his absence, in his physical absence, outside the courtroom, because it favors the state. I do no more than conclude by referring in dealing with the argument around the issue of the NPA we deserve, the NPA we must have, the NPA that the Constitution says we must have. It is an NPA that shall serve in terms of Section 32, that shall serve impartially and exercise and carry out or perform his or her powers, duties, and functions in good faith and without fear, favor, or prejudice, and subject only to the Constitution and the law. What we hear today, that a postponement would, for some reason, the postponement does not violate the rights of Mr. Zuma, but for some reason, the state is insistent that the matter can proceed virtually. Perhaps we should consider virtual imprisonment. And so Mr. Zuma would not necessarily have to be in prison physically in a prison, but virtually imprisoned.
Yeah, Mr. Masuku, either case is made out for the postponement or it isn't. Concerns about a particular attitude, I don't think really at the end of the day carry the day, do they?
No, they do, because my lord, you listen to Mr. Turngrove make arguments about how bad the plea is, and make arguments about that it should be dismissed. And I know that's for not, it's completely outside the terms of your directive. But you had submissions that were completely irrelevant for this purpose. And I'm suggesting that the only reason why those submissions were made, and you will see that there's a constant idea of churning out material that will suggest that Mr. Zuma is wasting the court's time, wasting the NPA's time. He should not be complaining about his fair trial rights. That will not happen. Mr. Zuma is entitled to the protection of the Constitution. It doesn't matter what the NPA believes about those rights. He will insist when they are violated. He will come to your lordship and he will say, please give me a postponement because what is about to happen will violate my rights. And a lot of people are now asking, why is this trial being conducted virtually when even civil matters are postponed to the 26th of July? What is the agency? What is this drive that the NPA insists on wanting this particular plea to be disposed of out of hand? They must be patient. They've tried their best for 15 years, and this matter will come before your lordship. The plea will be argued, and Mr. Wim no doubt will make those arguments that he made today. But today was not the time and the opportunity to make those arguments, because those were not covered in the scope of your directive.
Yes, I saw them having a relevance to what is alleged in one part of the founding papers. But I've heard your submission, so let's just, I think we don't have to take it any further.
No. It would be nice, my lord, if I heard you say something like, no, Mr. Masuku, I hear your point, and just leave it there. Because what Mr. Wim said was to ask you to dismiss the plea. You say dismiss the plea, dismiss the application to apply for oral evidence.
Mr. Masuku, I'm dealing with this matter, if it hasn't become apparent now, on the basis of an application for a postponement.
No, it is apparent, my lord. I'm not impugning your lordship's.
No, I just want to. No, I'm not suggesting you are. I just wanted to give you that assurance.
I'll take that to the bank, my lord. my lord, those are the submissions that we make. We ask for a declaratory order. We also ask that the matter be postponed and appropriate arrangements made for a constitutionally acceptable framework under which Mr. Zuma's trial can be conducted.
The postponement that you're asking for, is that a week?
I would suggest 3 weeks. 3 weeks would be appropriate, my lord.
And is that going to suit all counsel?
My lord, perhaps one of the directives you could make is that counsel then engage virtually to determine in the 3rd week which dates are suitable for the further conduct of the trial. Because who knows, my lord? I mean, I know that the state suggests that the disturbances are somehow linked to Mr. Zuma's arrest or incarceration in their founding affidavit. But what happens if, for example, next week there is another disturbance, and there is a need for us to come back to you and to say, my lord, we've got this problem, or the pandemic itself comes heavy in the courtrooms of the.
Well, what you say is that the directive might very well still be correct, depending on the circumstances.
Which directive, my lord?
The one I issued, that it should proceed by way of a virtual hearing.
No.
If conditions should become worse.
No, because then your lordship must engage with whether or not it's appropriate to conduct a virtual hearing of the trial itself.
Yes, no, but then it'll have to be determined in the prevailing facts at that point.
Yes, yes, certainly, because we're here because of the prevailing facts.
The terms in which it has been issued, it might be fine.
No. I've made my submissions on that aspect, my lord. I'm sure that your lordship would accept that. That's not what I'm saying. Or what I'm saying is that there is if you do grant a postponement, it does accord with the rights for which the postponement is granted, and it is.
Well, maybe I should then just fix a date if I am so disposed.
Well, if you do fix a date, obviously, if there should be a reason why that date fixed can't be complied with, we will come back to you and ask for. We really don't want to a situation where your lordship is not in control of the process going forward. If your lordship feels that a date should be fixed, then your lordship must fix a date. If your lordship feels that a better way is for council to engage with each other so that we come with an agreement on the dates, then your lordship could direct that. And if we can't come with a date, your lordship can then propose a date.
Yes, the matter was adjourned until today's date, for the trial to continue, wasn't it?
No, we've made the submissions, my lord. I can't. I can see where your lordship is going, and I particularly want to say that we accept that the trial was meant to continue today. There were circumstances that intervened for which your lordship addressed us on, and your lordship invited submissions. Your lordship issued directives. There was no need to issue directives.
What I'm trying to clarify, it was set down from now for the next couple of weeks, at least for the session.
No, the conditions won't change tomorrow, my lord. If the idea is to postpone it tomorrow.
I know that, but I'm just asking, was it not set down from today for the rest of the session?
It was.
Yes. Thank you. Yes. Anything further, Mr. Masuku?
Nothing further, my lord. Those would be our submissions.
Thank you. Yes. Can anybody still hear?
Yes, we are, my lord.
Yes,
thank you. This matter is adjourned then until tomorrow. I shall endeavour to give my ruling tomorrow at 10 o'clock. I'm not promising it will be with reasons, but probably with reasons to follow later. But I'll give my ruling tomorrow at 10.
Lord, may I just put on record that for your benefit and of my learned friends, that I am instructed that the prisons have made facilities available to Mr. Zuma to consult with his counsel in one of three ways, either by personal visit, unlimited personal visit, or unlimited use of a Zoom virtual platform, or unlimited use of a telephone.
Thank you. Thank you. We will meet tomorrow then at 10 o'clock.
Thank you, my lord.
Adjourn until.
Thank you, my lord.